morning everyone. I am Megan Angelisico from Group 5 and I am here to continue my reporting regarding e-commerce from Section 13 to Section 18. So, Section 13 is the retention of electronic data message or electronic document. Notwithstanding any provision of law, rule or regulation to the contrary, letter A, the requirement in any provision of law that certain documents be retained in their original form is satisfied by retaining them in the form of an electronic document which, number 1, remains accessible so as to be usable for subsequent reference, and second, is retained in the form in which it was generated, sent or received, or in a format which can be demonstrated to accurately represent the electronic data, message, or electronic document generated, sent, or received. So, number 3, it enables the identification of its originator and addresses as well as the determination of the date and the time it was sent or received. And letter B, the requirement referred to in paragraph A is satisfied by using the services of a third party provided that the conditions set forth in the paragraph number 1, 2, and 3 of paragraph A are met. In paragraph A, it remains accessible so as to be usable for subsequent reference. It means that you must be able to find, open, and read the file later. So you must have a reliable system for storage, backup, and retrieval. So in paragraph A, there are 3 SLB requirements. So first, it means the file must be real or unaltered version. So in this paragraph na ay 2 option, which is the original format and accurate representation. So original format, like i-save nimo siya originally, like delete nimo siya i-copy sa Word and any document nga imuhang na-receive. And then for number 2 is accurate representation. Mga katong mga email or documents nimo nga na-receive, kaya imo siya i-convert into PDF and maod na to siya imuhang i-save. 3, it enables the identification of its originator and addresses as well as the determination of the date and the time it was sent or received. So it means that you must save the document's context. For example, if email siya, you must kailangan na kay if imo man gani siyang for kanang like for example mo siyang i-copy into Word. So for example, sa email kailangan na kay header information which is the gikan from originator and kung kinsa ang gisendan niyo or ang addressee. And also dili sa imo sa yapi lang ihang timestamp kung when siya na-receive, when and ang time kung when siya na-receive o na-send sa originator. Paragraph A, diba, na ating mga requirements. So this data is what proves the document is authentic and ties it to a specific event and specific people. So in paragraph B, it means that the law explicitly allows you to outsource your digital record keeping. So mo katong requirements sa letter A, 1, 2, and 3 kailangan ma-meet to sa isa. The responsibility to meet the 3 conditions rests with you, not your provider. If your cloud provider loses your data, its systems fail to save the metadata or your mga document. So your company is the one in violation if ever man gani na nawala to sila. This is why choosing a reliable and secure third-party provider with good service level agreement is a critical business decision. So why Section 13 matters? First, it enables e-commerce. So without this, inconvenient na kaayo kung imo pa i-print ang katong mga send nila nga document. So in case nga kanang mangita ka, so inconvenience yun kung mangita pa ka sa mga printout. So mas dali lang yun if ever imo siyang i-save into drive and then yan na kang. So second, it is the standard for digital evidence. So mo na siya makakita evidence if ever nga mangayot sila. So number 3, it forces good IT governance. Section 14. The matters referred to in Section 12 on admissibility and Section 9 on the presumption of integrity. It may be presumed to have been established by an affidavit given to the best of the deponent's knowledge subject to the rights of parties in interest as defined in the following section. So Section 14 provides a practical shortcut for providing an electronic document is authentic and admissible in a legal proceeding. So instead of requiring testimony from IT expert, Section 14 allows a party to submit an affidavit to do the initial work. So why is it shortcut? It's because it shifts the burdens of proof. The party submitting the document doesn't have to prove it's authentic from scratch. The other party now has the burden to prove it's not authentic. So affidavit proves the admissibility in Section 12 and the presumption of integrity in Section 9. The affidavit is made by the deponent that qualified to speak on the company's system. So the legal effect anime is presumed to be established means the judge will assume the electronic document is authentic and admissible unless the other side challenges it. So Section 15, which is cross-examination. A deponent, paragraph 1, a deponent of an affidavit referred to in Section 14 that has been introduced in evidence may be cross-examined as of right by a party to the proceedings who is adverse in interest to the party who has introduced the affidavit or has caused the affidavit to be introduced. So in paragraph 1, Section 15 is a check and balance rule. It guarantees the right to challenge electronic evidence by cross-examining the people who claim it is authentic. So in Section 14, which is muna siya ang context. So sa Section 15, kay dito na mo diba i-check if it is authentic or not. And in Section 14, muna siya ang context that allows a party to use written affidavit, like maingon sila nga this or the electronic document I am submitting is authentic and my system is reliability. So in Section 15, i-check na nila. So panalitan mo to ang giingon sa lawyer na ang ilahang electronic evidence kay kuan kanang authentic. So from this side or so ang judge maingon ang judge na the court will presume this image is authentic based on affidavit. So in that case, ang katong lawyer sa isa ka party, which is dito na siya mga mukaan na sila ang check. I-check nila para ma-sure or like mukaan ang kanang evidence is authentic. So then ang result, ang IT manager na jud ang mo-testify in person sa question and siya ang admit. If manager admit the affidavit claims are weakened, then the judge may rule the email is not authentic. In paragraph 2, any party to the proceedings has the right to cross-examine a person referred to in Section 11, paragraph 4, subparagraph C. So the core function of this provision is to establish the legal equivalence between traditional and digital means of forming a contract. It ensures that the essential elements required by the Civil Code, for example, the consent, objectives or object and cause can be fulfilled digitally. So the phrase no contract shall be denied validity or enforceability on the sole ground that it is in the form of an electronic data message or document. It means there's a technology neutral rule that a judge cannot invalidate a contract just because it's an email instead of a handwritten document. So this rule only addresses the form of a contract. If the contract is invalid for other reasons, such as being illegal, having an impossible object, or lacking the legal capacity of one party, it remains invalid, regardless of whether it was paper or digital. The law simply removes electronic form as a basis for invalidity. So, paragraph 2 sa section 16, electronic transaction made through networking among banks or linkages thereof with other entities or networks, and vice versa, shall be deemed consummated upon the actual dispensing of cash or the debit of one account and the corresponding credit to another, whether such transaction is initiated by the depositor or by an authorized collecting party. So, provided that the obligation of one bank entity or person similarly situated to another arising therefrom shall be considered absolute and shall not be subject to the process of preference. So, in paragraph 2 in section 16 provides a clear objective rule for when a digital financial transaction is legally finished, removing ambiguity that could arise from the milliseconds involved in electronic processing. So, an electronic transaction is deemed consummated upon the happening, for example, ATM withdrawals. Upon the actual dispensing of cash, the transaction is final the moment the money is physically dispensed by the machine. And for the second event, for fund transfer. Upon the debit of one account and corresponding credit to another, the transaction is complete once the system has registered the money leaving the sender's account and arriving in the recipient's account. Section 17. Recognition by parties of electronic data message or electronic document as between the originator and the addressee of an electronic data message or electronic document. A declaration of will or other statement shall not be denied legal effect, validity, or enforceability solely on the ground that it is in the form of an electronic data message or electronic document. In section 17, it affirms that a valid agreement or statement addressed or expressed digitally is a real agreement or statement for the people who sent and received it. Section 18. Attribution of electronic data message. For paragraph 1, an electronic data message or electronic document is that of the originator if it was sent by the originator himself. In subsection 1, in section 18, the message is unequivocally the originators if they send it themselves. So, this section is establish the primary rules for attribution, legally assigning the message to the originator. So, in subsection 2, it is authorized or automatic sending. The message is deemed to be the originators if it was sent by a person who authorized to act on the originator's behalf. For example, our employee or agent. So, second is an information system like a server or application that was programmed or for the originators to operate automatically. In subsection 3, it addresses right to act consumption. This outlines situation where the recipient addressee is entitled to assume the message is authentic and act accordingly even if the originator didn't send it directly. So first, agreed security procedure in subsection 3. If the addressee properly applied a security procedure like password check or digital signature verification or encryption key that the originator had previously agreed upon and the result is verified, the message is origin. So in subsection 3b, access via relationship, if the message resulted from the actions of a person who gained access to the originator's identification method because of the relationship with the originator or the originator's agents, for example, an employee misusing a company password. In subsection 4, when the right to assume is lost. So the addressee loses the right to assume the message is authentic and must stop acting on that assumption if first, notice and time to act. The addressee received a notice from the originator that the message is not theirs and the addressee had a reasonable time to act on that notice. So in subsection 4b, knew or should have known. In the case of access via relationship, the addressee know or should have known by exercising reasonable care or using an agreed procedure that the message was not from the originator. In subsection 5a, which is the integrity of the message, discovers the message's content or integrity. So if a message is attributed to the originator under 1, 2, or 3, the addressee is entitled to regard the content as being exactly what the originator intended to send, and they can act on that. So exception, the addressee is not entitled to act on this assumption if they knew or should have known by exercising reasonable care or using an agreed procedure that the transmission is resulted in an error in the received message. So subsection 6 is the duplicate messages. So this addresses the issue of receiving the same message more than once. First is the addressee is entitled to regard each message received as a separate message and act on it. So except the addressee cannot act on the assumption of separateness if they knew or should have known that the message duplicates another and that they should have spotted it by exercising reasonable care or using an agreed procedure. So this prevents an addressee from, for example, processing the same electronic payment